The senator for Connecticut.
Thank you very much, Mr. President. Mr. President, I come to the floor today to talk for just a few quick moments about what the stakes are as we begin this debate over a new swing vote on the United States Supreme Court. This is a fairly simple chart listing off a number of pre-existing conditions that tens of millions of Americans have. And what it says is that the Supreme Court could take away your health care if you have a history of cancer, diabetes, heart disease, stroke, cerebral palsy, mental illness, ALS, lupus, epilepsy, Parkinson's, the list goes on. The reason for this is that the new priority for those that oppose the Affordable Care Act and the protections that are built in it for Americans who are sick or have ever been sick, their new strategy is to use the court system as a means to try to invalidate the protections in the law for people with pre-existing conditions. Protections, by the way, that Republicans said that they supported during the debate over the Affordable Care Act. The case is currently before the district court level. It's Texas v. United States. And it has drawn interest because of an exceptional decision by the Trump administration. The Trump administration has decided to weigh in on behalf of the petitioners, abandoning the traditional role of the executive to defend a statute. Traditionally, an executive will defend a statute regardless of whether they politically support it or not, because who else will defend the statute if not the Department of Justice and the United States government? In this case, the Trump administration is going to court to argue that the United States Congress cannot, under the Constitution, provide protection to people with pre-existing condition against discrimination and rate increases from insurance company. Now, this should freak out the tens of millions of Americans who have pre-existing conditions, because without the protection that's in the law today, health care will be unaffordable and unavailable to the over 100 million Americans who have any history of disease. Now, given the importance that the Trump administration has placed on this case by weighing in this exceptional, unprecedented way on behalf of those that are trying to pull apart protections for people with pre-existing conditions, we have to prepare for the fact that this case may move from the district court to the appellate court and eventually to the Supreme Court. And if it does, this seat that we are about to debate will potentially be the deciding vote as to whether Americans in this country who have pre-existing conditions will continue to be able to get health care. And so I just wanted to come to the floor as we start to set the table for this conversation to make very clear what the stakes are. The Trump administration has taken the exceptional position of arguing against people with pre-existing conditions, saying that Congress cannot, by law, protect people with pre-existing conditions. President Trump, as a candidate, made it very clear that his priority was to put justices on the court who would correct for the fatal flaw of John Roberts. He identified that fatal flaw as John Roberts' defense of the Affordable Care Act. He made a promise that he wouldn't make that mistake again. He would not put somebody on the court who would vote to uphold parts of the Affordable Care Act. You got to take the president at his word. Most of the things he said he would do as president of the United States when he was a candidate, he has done. A lot of folks here didn't take him seriously, didn't think that he would really try to unwind NATO, didn't think that he would really try to ban Muslims for the United States, didn't really think that he'd pursue this crazy idea of a wall. He did all those things. And so let's take him at his word when he says that he is not going to appoint a Supreme Court justice that will uphold the Affordable Care Act. And the case that is moving up to the Supreme Court today is a case that would take away protections for people with pre-existing conditions. Second, he essentially outsourced the decision over who would be his nominee to these two political groups, the Federalist Society and the Heritage Foundation. Now, we know where the Heritage Foundation is on the Affordable Care Act. They have basically made it their mission over the course of the last 7 years to try to destroy the Affordable Care Act. They have essentially written the legislation that has been put before this Congress on a variety of occasions to try to replace the Affordable Care Act with something that provides no protections for people with these illnesses. But the Federalist Society is in this game, too, of trying to attack the Affordable Care Act. NFIB versus Sebelius, one of the main judicial attacks on the Affordable Care Act. One of the lead counsels of record was a Federalist Society member, and 24 other Federalist Society members signed and filed amicus briefs in support of this judicial attack against the Affordable Care Act and the protections for pre-existing conditions. And so the Heritage Society and the Heritage Foundation, the Federalist Society have been in the business of trying to take away protections for people with pre-existing conditions from the beginning of this fight. And so when you outsource the selection of Supreme Court justice to those groups, you know what you're going to get. You are going to get a justice who is going to vote to unwind these protections. And you don't have to do that kind of super sleuthing because the president effectively already told you that he was going to appoint someone who would remedy the fatal sin of John Roberts, which was to uphold at least a central tenet of the Affordable Care Act. So I understand what Senator Cornyn is saying, that, you know, we should just accept that the nominee, when he comes before the Judiciary Committee, isn't going to answer any questions, and that we shouldn't assume anything that we don't know. But we have some pretty good evidence thus far. In addition, we have Judge Kavanaugh's writings, Judge Kavanaugh's attacks in his judicial opinions on the Affordable Care Act. Seven Sky is a really interesting case that came before the D.C. Circuit Court. It essentially, in the end, upheld the constitutionality of the individual mandate. Judge Kavanaugh dissented, and in that dissent, and I'll admit it was an interesting dissent, people should read it, but in that dissent, he goes out of his way to suggest that Congress has gone far afield from its constitutional limitations in adopting the Affordable Care Act. He writes in his dissent that the individual mandate is unprecedented on the federal level in American history, and predicting that by upholding the mandate, it would usher in a significant expansion of congressional authority with no obvious principled limit. Now, those are extraordinary words. Now, it's interesting because if you read the dissent, it in fact hints that ultimately the individual mandate can be upheld as a tax. And so I want to acknowledge the subtleties that are in that dissent. But that's an extraordinary phrase, that upholding the individual mandate would usher in a significant expansion of congressional authority with no obvious principled limit. Well, the obvious limit is the Constitution. And the idea that judges would decide what the principled limit is, other than the Constitution, I think is something that should be part of our debate here. And the fact that Judge Kavanaugh went out of his way to talk about his fears as to how broad the Affordable Care Act may be, in addition to his inclusion on the Federalist Society and Heritage Foundation list, and in addition to Trump's very clear signaling that he is only going to appoint a judge who is willing to overturn the Affordable Care Act, tells you that if you have any of these conditions, you are in the crossfire right now. 130 million people in America have pre-existing conditions. 130 million people. Let's just take a few of these just to give you a sense of the scope of the threat. There are more than 15.5 million cancer survivors in the United States today. 23 million Americans have been diagnosed with diabetes. There's about 100 million adults who have high blood pressure, about 100 million more that have high cholesterol. There are 26 million Americans that have diagnosed asthma. 44 million Americans have mental illness. 400,000 diagnosed with multiple sclerosis. 28 million Americans have been diagnosed with heart disease. And without the protections of the Affordable Care Act, if you have these diagnoses, you likely won't be offered health care. That's what happened prior to the protections for people with pre-existing conditions. You just weren't even offered a plan if you had some of these conditions. But if you were offered the conditions, you were offered them at rates that were unaffordable. Here's some data based off of CMS's calculations around operated risk adjustment methodology. They say that for folks that have diabetes without complication, the increase in rates without protections for people with pre-existing conditions could be about $5,600 a year. If you have a drug dependence, if you have an addiction, the increase could be $20,000 a year. If you've had a heart attack, a history of serious heart disease, your increase could be $60,000 a year. If you have metastatic cancer, you could be paying a 3,500% premium. That's $140,000 in additional surcharge a year. Obviously, nobody can afford that. That's why if you have a history of metastatic cancer, you're not getting offered insurance unless you have that protection. And so those are the stakes. I just want to make people understand that we are going to have a big debate over what Judge Kavanaugh will mean for the future of reproductive choice in this country, women's access to contraception. Those are really, really important debates. But I want to make everybody understand that this case is coming. Texas v. United States is moving through the court system. It is moving through the court system in part because the Trump administration is trying to get the judicial branch to invalidate protections for people with pre-existing conditions. Despite the fact that the president told us that he liked that part of the law, he has now instructed his judicial department, instructed the Attorney General's office to try to strip away protections for people who have high cholesterol, mental illness, cerebral palsy, multiple sclerosis. And it may be that this seat on the Supreme Court is going to decide that case. I think we can be pretty sure of how Judge Kavanaugh is going to rule. His hostility to the Affordable Care Act in his writings, his inclusion on lists by groups that have worked for years to undo these protections, and the clear signal from the president that he was only going to pick individuals for the court that would unwind the Affordable Care Act tells you how big the stakes are. The Supreme Court can take away your health care if you have any of these diseases, and that likelihood that they will take away your health care if you have any of these pre-existing conditions is radically increased if Brett Kavanaugh is confirmed. I announced last night that I will oppose his nomination. I will be down on the floor talking at length about many of the reasons why this body should reject his nomination. But at the outset, I wanted to make clear that this debate over the future of pre-existing condition protections for people in this country, 130 million people who have pre-existing conditions, needs to be at the center of this conversation over Brett Kavanaugh's nomination. I yield the floor.